test.
Here's what I want. I want 2 weekly tests over at community corrections.
Your Honor, would it be possible for her to do that with her parole agent in Grand Rapids?
I want 2 tests here.
Yes,
Okay.
sir.
So
Okay, could we
Go ahead.
come back in 2 weeks, Your Honor? So
That's what I want to do. I
Okay.
was going to adjourn it out 2 weeks, but I want 2 tests here
Like
showing me that she's clean.
I can do one today?
You can do one today.
Okay, okay.
This case, People versus Joe Torres.
Ron Brown appearing on behalf of Mr. Torres.
Your name?
Joe Torres. Please set an exam.
You have all the discovery.
Yes, Your Honor.
People have will the people have their witnesses available to 10?
We'll do our best, Joe.
Preliminary examination in person, February 10th, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
Thank you.
9 o'clock.
Bond continued. Court calls case People versus Terry. Is it Van Tunen? Think I'm pronouncing that wrong.
The U is silent.
You. I think you told me that
I did
last time.
that. I
didn't you?
did.
Hold on a second. I think it's Van Tynen.
Van Tynen.
Van Tynen.
Yes.
All right. We're good. All right. What are we doing?
A lot.
Joy Gaines, Senior Assistant Public Defender, representing Ms. Van Tynen. Your Honor, we submitted a plea form.
Yeah, we got a problem. You see her updated progress report?
I did, Your Honor.
Did?
Yes, if we could address, I believe that, well, is that the one with perhaps I did not.
It's from yesterday.
We are prepared to address this.
Pardon?
We are prepared to address this.
Go ahead.
Start. So Ms. Van Tynen has indicated that she has been in communication and in cooperation with her parole agent. As is stated in this report, that she has been testing for the parole agent. Her parole agent she actually showed me a series of text messages that she received from her agent verifying that
I'm not so much concerned whether she's testing or not. It's the results of the testing that are a problem.
So there's the one that she missed. And for that one on January 13th, the one January 12th, the result was negative. The one January 6th, the result was negative. The one January 13th, she indicated that she came to test here, but she did not realize that there was a fee. She has $12 today and is prepared to go test, and she indicates that it will be negative. She also has where she has completed as part of her parole conditions, a after recovery program. And so she is very sure that she will not test.
Here's what I want. I want 2 weekly tests over at community corrections.
Your Honor, would it be possible for her to do that with her parole agent in Grand Rapids?
I want 2 tests here.
Yes,
Okay.
sir.
So
Okay, could we
Go ahead.
come back in 2 weeks, Your Honor? So
That's what I want to do.
Okay.
I was going to adjourn it out 2 weeks, but I want 2 tests here
Like
showing me that she's clean.
I can do one today?
You can do one today.
Okay, okay, great.
Yeah. So I'll adjourn the probable cause conference to February 12th, 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you.
We're preparing that order on that.
So I can come back today and anytime next week.
we'll see
Court calls the case People versus Tony Walker Ross. Anthony.
Ron Brown appearing on behalf.
I messed that up. It's T. Anthony.
Yeah.
Yeah, they just throw it all together in one thing, but I see it up on the screen.
Your Honor, he's
Hold on a second.
going to waive,
No, hold on. What? What is it funny?
Yeah.
It is?
What?
You okay? It's been a day. Go ahead, yes, what are we doing?
he's going to waive exam, go to circuit court and plead up there.
Okay, is there an offer that he's pleading to or what?
Yeah, he's pleading to retail fraud first with hide-in restitution.
Is that the agreement? Yes. Okay. All right, so you're waiving your right to have a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive the right preliminary examination having been waived, defendants bound over circuit court on both counts.
Ron Brown appearing on behalf of Mr. Walker Ross. Waive reading, stand mute, request adjourn pretrial date so that we can do the plea up there.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 before Judge Judy.
March 24th, 2026, 1:30, Judge Cook.
Bond continue, please.
Bond continued.
Thank you.
Thank you.
Thank you. Court calls case of the people versus Pierre Williams. Somebody's gonna have to sign off.
Good afternoon, Your Honor. Raymond Cook.
Good afternoon, Your Honor. Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Williams. Would you state your name?
Tia Williams.
What are we doing? I have a plea form that indicates that the defendant is going to be pleading guilty to two charges, larceny 200 to 1,000, both of those. I don't know what the height after that means, but she's pleading to those two charges. Both 1-year offenses. Upon her successful plea to that charge, count 1 and count 2 would be dismissed. Defendant agrees to pay restitution of $100, and there is a sentence agreement that she will be sentenced under HIDA. That's the court's full understanding of the agreement.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Tia Williams.
Ma'am, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding? First charge, well, they're both the same charge. So count 3 and count 4 is larceny 200 to 1,000. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If it's greater than $2,000, that becomes the maximum fine. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty
Yes.
to the charge of larceny 200 to 1,000 as contained in count 3. How do you plead?
Guilty.
To that same charge as contained in count 4. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will? And also because you believe that you are indeed guilty of these offenses?
Yes.
January 1st, 2025, at the location in Washtenaw County. What did you do that makes you think that you're guilty?
I made a transaction on a car that did not belong to me.
I'm sorry,
Made a transaction on a card that didn't belong to me.
did you make just one transaction?
Yes.
Over
Over the
Pardon?
2 transactions.
Say again?
2.
You made 2 transactions. So you had a card that didn't belong to you,
Yes.
correct? And then you attempted purchases or something
Yes.
with that card. You did that twice.
Yes.
Is that right?
Yes.
Were they successful or was it just an attempt to purchase?
Your Honor, I believe that she was successful with the transactions.
Okay, so she was successful with the transactions. Were each of those transactions either for goods or services in excess of $200?
Yes.
And each one,
Yes.
correct? Okay. You didn't have anybody's permission to do that, did you?
No.
All right. That's it. Ma'am, if I accept your plea, I need you to understand that if you commit misconduct as defined under the Michigan court rules between the time of the plea and the time of your sentencing, that the court would no longer be obligated or bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are there any other pleas, any other promises, threats, or other inducements which you're aware of which led to this plea?
None from the people.
No,
All right. And have I complied with the court?
Yes, Your Honor.
defense is also satisfied.
Court will accept the defendant's pleas to counts 3 and 4. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
February 25th at 12 p.m.
February 25th, 2026, 12 noon. Before me. Bond will continue.
Thank you very much.
Thank you. Court calls the case of the people versus Stephen Yaney. Give me a couple of those. A few of them.
Assistant Public Defender Dr. Lee, on behalf of Mr. Yanni. Mr. Yanni, can you state your name, sir? And Your Honor, I do have a green sheet. Mr. Yanni indicated to me that he would like an adjournment in order to retain counsel.
So you're seeking to obtain your own counsel, sir? How long is that going to take you? Because I'm only giving you one adjournment for that purpose.
Waiting, I already did my client intake. I'm just waiting to hear back from him.
I'll adjourn this to February 19th, 2026, 9 a.m. for you to seek counsel. But like I said, I'm not granting any other adjournment for that
I
purpose.
did have one other question. I take my mother out of state, Pennsylvania.
To take your mother out of state?
Yeah, to
Does she want to go? Or you just, what?
It's a state business. She just wants me to go with her. It's a state business she has to take care of.
Which state?
Your Honor, I believe he's saying estate.
A state. Okay, you want to go to Pennsylvania.
For the
It's
15th.
business involving an estate. Your mother would like you to go with her. Is that your mother in the yellow?
Yes.
Is that a Steeler jacket? Then you can go. Any objection from the people in that regard? All right, defendant may travel to state of Pennsylvania with his mother. What dates were you going?
The 15th to 18th.
Of February? Yes, all right, I'll give permission to travel. You're welcome.
Your Honor.
Thank you. Have a good afternoon.
Take care.
Thank you.
Court does call the case of the people versus Anthony Alfredo Callejas.
Your Honor, Raymond Cook with the people.
Attorney Zach Baum on behalf of the defendant, who should be joining us by Zoom. Anthony, if you're there, turn your screen on, please.
See, you have him? We don't have him.
Well, can we just pass it for a moment?
Callejas? We don't have him.
Can we just pass this for a moment? I know I sent him off the email with the Zoom login. I just spoke to him yesterday, said he'd be here.
I'll pass it. Don't know when we'll get back to it, but I'll pass it.
Thank
Court
you,
calls
Your
case Robert Lee Brabs.
Dan Garrett on behalf of Robert Brad stepping forward.
Your name, sir?
Your Honor, if we could have an adjournment, there's further discussion with the people.
19th or 12th.
19th is great.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continued. Court calls the case of the people versus Brett Ward.
Alex Jablowski for the people.
Dan Garrett, on behalf of Brett Ward, who should be here on Zoom, Your Honor.
Brett Ward.
All right, he's waiving.
He is waiving, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Could I waive reading, stand mute, please?
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 25th at 1:30 before Judge Conlon.
March 25th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case of the people versus Stephen Winchester.
Dan Garrett, on behalf of Steve Winchester. Steve, can you identify yourself?
Good afternoon, Your Honor. My name is Stephen Winchester.
Thank you, sir.
Your Honor,
Requesting an adjournment.
Yeah, indeed, yes.
That objection, February 19th, 2026, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the people versus Adrian Bryan.
Good afternoon, Your Honor. Jordan Goldberg, P87047. I'm standing in for counsel of record Stephen Sharg on behalf of Adrian Bryan.
Bryan?
Yes, sir. Sorry.
Any objection to counsel? Any objection to counsel stepping in?
No, sir.
All right. And state your name again, sir.
Adrian Bryan.
All right. What are we doing?
Your Honor, my understanding. Oh.
Thank you.
Is that correct, counsel? Asking for an adjournment?
That's correct.
Probable cause conference adjourned February 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case people versus Julian Castle.
Afternoon, Your Honor.
Good afternoon, Your Honor. Steve Tremontian with it on behalf of the defendant, Mr. Castle, who appears by Zoom. Mr. Castle, could you unmute and state your name?
Yes, it's Julian Castle.
Thank you.
Your Honor, this is going to be a waiver. Mr. Castle is in Colorado. I was starting to fill out the form. I don't have his signature on it, but could we do this verbally?
But I'll voir dire.
Thank you.
Mr. Castle,
Yes.
you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, sir. There was an offer extended, if I can place that on the record.
Yes.
There was an offer extended to plead to a single added count 3 of a use of a controlled substance and the dismissal counts 1 and 2. That offer will remain open at first circuit court retrial.
All right, very good. Defendant having waived preliminary examination, defendant is bound over on counts 1 and 2. That's the amendment.
We will waive formal reading. My client will stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter not guilty plea. Pretrial will be
March 23rd at 1:30 before Judge.
March 23rd, 2026, 1:30 before Judge Hammoud.
Thank you, Judge.
Bond continued. Court calls case people versus Shania Jazir.
Go for the people.
Good afternoon, Your Honor. Christina Saxon for Shania Desir, who's present by Zoom.
Ms. Jazir, can you state your name, please?
Shania Desir. We're just setting for a preliminary exam.
Both cases?
Yes, please.
Discovery is complete.
I think so.
People have their witnesses available the 10th. Preliminary examination in person, February 10th, 2026, 9 a.m. before Judge Fresh Hour. Thank you.
Thank you.
Thank you.
Court calls case People versus Eric L.Z. Williams.
Your Honor, Sam Bernstein with and on behalf of Mr. Elsie Williams.
Eric L.Z. Williams.
The plea is what we're doing.
Yes, Your Honor.
All right. The court's understanding of the plea is that he's going to plead to 3 misdemeanor charges. The first one being discharge while aimed without malice and injury, discharging a firearm. Basically, improper discharge of a firearm without malice or injury, the 1-year offense. The count 5 and count 6, both being reckless use of a firearm. The 90-day offenses, $500 fine plus court costs, and both requiring mandatory forfeiture of device or weapon. But on his successful pleas, counts 4, 5, and 6, counts 1, 2, and 3 would be dismissed. That is the court's full understanding of the agreement.
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
What's your name, please?
Eric L.Z. Williams.
All right, sir, it is this court's understanding you're going to plead guilty to 3 misdemeanor charges. Is that your understanding?
Yes.
All right, the first being reckless use of a firearm while aimed, discharge of a firearm while aimed without malice and without injury. That's a misdemeanor punishable by up to 1 year incarceration, $500 fine plus court costs and forfeiture of the weapon and or device. You understand that, sir?
Yes.
Counts 5 and 6 are the same, which are reckless use of a firearm. Those are punishable by up to 90 days in jail, $500 fine plus court cost on each count. You understand that, sir?
Yes, Your Honor.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
Still plead guilty?
Yes.
All right. To the charge of discharge while aimed of a firearm without malice or injury, how do you plead?
Guilty.
To the charge of reckless use of a firearm as contained in count 5, how do you plead?
Guilty.
To that same charge as contained in count 6, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I understand.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 of that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything?
No.
Get you to plead other than what's been stated here today?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty?
Yes.
All right. October 24th, 2025, at the location of 8990 MacArthur Boulevard, Superior Township, Washington County, State of Michigan. Did you discharge a firearm?
Yes.
Did you aim it prior to discharging it?
No.
You just discharged the firearm?
Yes.
In public? Where
were you? In a building.
You were in a building?
Yes.
And you discharged the firearm while you were in that building?
Yes.
All right. You weren't intending to hurt anybody or to do any damage, you just did it?
No, sir.
You just did it, right?
Yes.
All right. And how many times did you do that? Was there only one weapon that you discharged?
Yes.
And How many times did you discharge the weapon?
3 times.
Okay. Got it. So you did that at least 2 times, recklessly discharge and use that firearm. Is that correct?
Yes.
All right. Sir, if I accept your plea, you do understand that between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw these pleas, and the court would not be bound by any sentence evaluation or recommendation.
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 4, 5, and 6. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered. 14A2 probation. Sentencing in this matter will be
At 10 a.m. before Judge Barr.
February 17, 2026, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Michelle Lovas.
Secretary for the People, Your Honor. John Shea, Your Honor, working on behalf of Ms. Lovas.
Hello. State your name.
Michelle Lavaz.
Take your hands out of your pockets.
Your Honor, made Mr. Kennedy and I.
Logistical things, I guess we'd call them, or bureaucratic things. So probable cause conference in this case will be adjourned February 26, 2026. 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you. Thank you. Court calls the case, People versus Tabitha O'Carroll. Yeah.
Good afternoon, Your Honor. J. Grant Miller, P58658 on behalf of Ms. O'Carroll, who appears via Zoom.
Ma'am, can you state your name?
Tabitha O'Carroll.
All right. I have a plea agreement. Is that what we're doing today?
Yes, Your Honor.
All right. Plea agreement indicates she'll be pleading to retail fraud in the 2nd degree, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. It's a 14A1 case. You check the sentencing judge waiver, but it would remain here. All right.
Very well, Your Honor.
That's the court's full understanding of it.
That's correct, Your Honor.
All right. Very good. Ma'am, can you please raise your right hand to be sworn? All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. State your name again for the record.
Tabitha O'Carroll.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the 2nd degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, sir.
All right, you can put your hand down, ma'am. All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. The basis for the no contest plea, Mr. Miller?
Your Honor, due to my client's medical condition and she has a memory disorder, she has no specific recollection, so we sent over the police report.
So lack of recollection.
Yes, Your Honor.
So ma'am, to that charge of retail fraud 2nd degree, how do you plead?
No contest plea?
Yes. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you'll be giving up all those rights, including the rights contained in paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-21121. Any objection to the court having reviewed that report from counsel?
None from the people.
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from defense, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14-1 probation. Sentencing will be February 25th, 2026, 12 noon before me. Bond will continue.
Thank you, sir.
Thank you, ma'am.
Thank you, Your Honor. Is it possible if
Thank
somebody could put the phone number into the chat so I can text it to my client?
I don't know if I have people here. Do you have the phone number? You don't have the phone number. And please, apparently you work for him too. Thank you. Court calls the case, People versus Trimal Ross.
Sherilyn Foster Tucker on behalf of Trammell Ross.
Sir, your name?
Tramiel Ross.
Your Honor, we're requesting a preliminary exam.
Discovery is complete.
To my knowledge.
Yes. People, either witnesses available the 10th.
Yes.
Preliminary examination in person, February 10th, 2026. 9 a.m. before Judge Garwood. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Alexander Sanchez Garcia.
Afternoon, Your Honor. Nicholas Monterez on behalf of Alexander Sanchez Garcia, who is ready to get going up there on Zoom.
Apparently he is. Sir, if you can now state your name.
Alexander Sanchez Garcia.
All right, great. You're seeking adjournment.
I am, Your Honor. Apologize for the chicken scratch.
Boy, that's bad. No, I'm kidding. All right. Will the 19th work for you?
Your Honor, maybe a little more time than that. And if the court would like to speak, then I'd ask that me and Kennedy be able to, Mr. Kennedy be able to approach.
I can do the 20. Yes, we've had a couple, but I can do the 26th or the 5th. March,
5th works best for me, Your Honor.
of course. That's what you would say.
Your Honor, I believe we are close to,
Agree with that, Your Honor.
Probable cause conference will be adjourned March 5th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Your Honor.
Thank you. Court does call the case of the people versus Jeremy Shue.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Shue, who I believe is on Zoom.
Yep, I think he's there. Jeremy? Where'd he go?
We're prompting him. He's the scales.
Oh, there he is. Yeah.
All right, there we go. It took me a minute to.
All right, state your name.
Jeremy Shue.
All right.
Thank you, Your Honor. We have the same situation we had last time where Mr. Shue has an active interlocutory appeal in a companion case that's dispositive here. In that case, Judge Washington just ordered a stay. I'm asking today either for another adjournment or if you'd consider a parallel stay as well.
I won't at this time, but he has an appeal pending on a.
It's a suppression motion that impacts this case as well.
Got it. Okay. Has the appeal been granted or?
No, it's on application.
On application. Okay, that's what I was trying to figure out. So let me do this. Probable cause, let me adjourn it out to March 12th, 2026, 9 a.m. as your invite indicates. And counsel, at the next hearing, if we haven't heard anything or if the application's granted and they're working it through, then I would certainly consider a stay.
Okay. Thank you, Your Honor. I appreciate it.
Thank you. Thank you, Mr. Shue.
Thank you, sir. Have a good day.
You too. Court calls the case, the people versus Jamie Schultz. They're in Zoom, yeah.
We're on Zoom, Your Honor. Edward Zany on behalf of Mr. Schultz, appearing via Zoom.
All right. Sir, can you please state your name?
Yes, sir. Jamie Schulte.
All right. And what are we doing on this case?
Your Honor, today's date and time schedule for probable cause conference, we provide the court with a misdemeanor plea agreement to which my client will be pleading guilty to a count 2, added count 2, refusal to obey a traffic order in violation of MCL 256.
I don't have anything.
We sent it in with the advice of rights, Your Honor, and the.
When did you send it?
Yesterday.
You see it at all? It's not on you. I know.
The only thing I have from their office is
The only thing we got from you, according to my staff, is a Zoom request. I don't know where they sent it.
Well, Your Honor, I can send it over right now if the court would allow. It's.
Is it signed off by everybody?
Yep, signed off by my client, Mr. Childers, myself.
Go ahead and send it. We don't have to deal with you anymore. Court pass it.
Okay, Your Honor, thank you.
Court calls the case, people versus Jacob Sims.
Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Sims. Your Honor, I don't know if I see Mr. Sims in the courtroom. I've tried to contact him regarding today and have been unsuccessful.
Sims? I don't have him.
Your Honor, I would ask, of course, for an adjournment if you would be so inclined so that I can contact Mr. Sims.
Not inclined. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately. Thank you.
The judge stopped the plea cold after reviewing a troubling progress report, missed tests, unpaid fees, and excuses that didn't sit right. The defense insisted she was clean, claiming negative results and promising another test that same day, but the judge wasn't gambling with trust. Instead, the court demanded proof. 2 clean tests in court, no shortcuts. The message was clear. Words don't win freedom, actions do. Now everything rides on what those test results show. Should the judge have given more time, or was this the right call? Like, share, and follow for real courtroom drama.